Chapter 27. Ethical Issues in Public Sector Accounting and Finance. Contents: 1. Purpose. 2. Introduction. 3. Economic and Financial Crimes Commission (EFCC). 4. The Corrupt Practices and Other Related Offences Act 2000. 5. Code of Conduct for Public Officers. 6. Paragraph 11 of the 5th Schedule, Part 1. 7. Code of Conduct Bureau. 8. Code of Conduct Tribunal. 9. Nigerian Extractive Industries Transparency Initiative Act 2007. 10. General Rule. 11. Chapter Review. 12. Worked Examples. Ethical Issues in Public Sector Accounting and Finance. Purpose. After studying this chapter, readers should be able to A. Identify and discuss the major institutions charged with the responsibilities of ensuring compliance to ethical standards in the public sector, and B. Itemize ethical offenses and discuss the appropriate stipulated sanctions. Introduction. In order to stamp out the rising cases of corruption, fraud, greed, and avarice which are pervasive in the society, and in view of the need to overhaul the image of the country before accountability organs such as Transparency International, the Federal Government of Nigeria introduced various regulative laws and measures. Economic and Financial Crimes Commission (EFCC). The EFCC was established by Act No. 5 of 2002, effective from 14th December, to combat economic and financial crimes in Nigeria. The Commission is empowered to prevent, investigate, prosecute, and sanction economic and financial crimes, and is charged with the responsibility of enforcing the provisions of other laws and regulations relating to economic and financial crimes, such as the Money Laundering Act 1995, the Advanced Fee Fraud and Other Related Offences Act 1995, the Failed Banks, Financial Multi-Practices in Banks Act 1994, the Banks and Other Financial Institutions Act 1991, and Miscellaneous Offences Act. Composition. The Commission shall consist of the following members: A. 1. A chairman, who shall be the Chief Executive and Accounting Officer of the Commission. 2. A serving or retired member of any government security or law enforcement agency. B. A Director General, who shall be the head of administration. C. The Governor of the Central Bank or his representative. D. A representative each of the following federal ministries, not below the rank of a director: 1. Foreign Affairs. 2. Finance. 3. Justice. E. The Chairman, National Drug Law Enforcement Agency. F. The Director General, the National Intelligence Agency. G. The Director General, the Department of State Security Service. H. The Director General, Securities and Exchange Commission. I. The Commissioner for Insurance. J. The Postmaster General, Nigerian Postal Services. K. The Chairman, Nigerian Communications Commission. L. The Comptroller General, Nigeria Custom Services. M. The Comptroller General, Nigerian Immigration Services. N. a representative of the Nigerian Police Force not below the rank of Assistant Inspector General. O. 4 eminent Nigerians with cognate experience in finance, banking, or accounting. Duties. According to Part 11 of the Act, the Commission is responsible for A. The enforcement and due administration of the provisions of the Act. B. The investigation of all financial crimes, which include advance fee fraud, money laundering, counterfeiting, illegal charge transfers, future market fraud, fraudulent encashment of negotiable instruments, computer credit card fraud, contract scam, etc. C. The coordination and enforcement of all economic and financial crime laws and enforcement functions conferred on any other person or authority. D. The adoption of measures to eradicate the commission of economic and financial crimes. E. The adoption of measures to identify, trace, freeze, confiscate, or seize proceeds derived from terrorist activities, economic and financial crime, crime-related offenses, or the properties, the value of which corresponds to such proceeds. F. The adoption of measures which include coordinated preventive and regulatory actions, introduction and maintenance of investigative and control techniques on the prevention of economic and financial related crimes. G. The facilitation of rapid exchange of scientific and technical information and the conduct of joint operations geared towards the eradication of economic and financial crimes. H. The examination and investigation of all reported cases of economic and financial crimes with a view to identifying individuals, corporate bodies, or organs involved. I. The determination of the extent of financial loss and such other losses by government, private individuals, or organizations. J. Collaboration with government bodies, both within and outside Nigeria, carrying on functions wholly or in part analogous with those of the Commission concerning 1. The identification, determination of the whereabouts and activities of persons suspected of being involved in economic and financial crimes. 2. The movement of proceeds or properties derived from the commission of economic and financial and other related crimes. 3. The exchange of personnel or other experts. 4. The establishment and maintenance of a system for monitoring international economic and financial crimes in order to identify suspicious transactions and persons involved. 5. Maintaining data, statistics, records, and reports on persons, organizations, proceeds, properties, documents, or other items or assets involved in economic and financial crimes. 6. Undertaking research and similar works with a view to determining the manifestation, extent, magnitude, and effects of economic and financial crimes, and advising government on appropriate intervention measures for combating same. K. Taking charge of supervising, controlling, coordinating all the responsibilities, functions, activities relating to the current investigation and prosecution of all offenses connected with or relating to economic and financial crimes, in consultation with the Attorney General of the Federation. L. Carrying out such other activities as are necessary or expedient for the full discharge of all or any of the functions conferred on the Commission under the Act. Powers. Under paragraph 6 of the Act, the Commission has power to a. Cause investigations to be conducted as to whether any person has committed an offense under the Act. b. Cause investigations to be conducted into the properties of any person if it appears to the Commission that the person's lifestyle and extent of his properties are not justified by his source of income. c. Enforce the provisions of 1. The Money Laundering Act 1995. 2. The Advance Fee Fraud and Other Related Offences Act 1995. 3. The Failed Banks, Recovery of Debt, Financial Practices in Banks Act 1994 as amended. 4. The Banks and Other Financial Institutions Act 1991 as amended. 5. Miscellaneous Offences Act, and 6. Any other law or regulations relating to economic and financial crimes. Offences and convictions. A summary of the various offences committed and the penalties stipulated under Part 4 of the Act is a. Offences which relate to financial malpractices, 5 years imprisonment or a fine of 50,000 naira, or both imprisonment and fine. b. Offences associated with terrorism, imprisonment for life. c. Offences committed by public officers, between 15 and 25 years imprisonment. d. Retaining the proceeds of a criminal conduct, not less than 5 years imprisonment, or to a fine equivalent to 5 times the value of the proceeds of the criminal conduct, or to both fine and imprisonment. e. Offences in relation to economic and financial crimes, imprisonment for a term not less than 50 years, 15 years, and not exceeding 25 years. Paragraph 20 of the Act says, for the avoidance of doubt and without any further assurance than this Act, all the properties of a person convicted of an offense under this Act and shows to be derived or acquired from such illegal act and already the subject of an interim order shall be forfeited to the federal government. The Corrupt Practices and Other Related Offences Act 2000. The Corrupt Practices and Other Related Offences Act 2000 gave birth to the Independent Corrupt Practices and Other Related Offences Commission. The Commission is a body corporate endowed with perpetual succession. It has a common seal and is juristic, that is, may sue and be sued in its corporate name. Composition of the Commission. The Commission shall consist of a chairman and 12 other members, 2 of whom shall come from each of the 6 geopolitical zones, thus: a. A retired police officer not below the rank of Commissioner of Police. b. A legal practitioner with at least 10 years post-corps experience. c. A retired judge of a Supreme Court record. d. A retired public servant not below the rank of a director. e. A woman. f. A youth not being less than 21 or more than 30 years of age at the time of his or her appointment. g. A chartered accountant. The chairman shall be a person who has held or is qualified to hold office as a judge of a superior court of record in Nigeria. Appointment of members. The chairman and members of the commission, who must be persons of proven integrity, shall be appointed by the President upon confirmation by the Senate, and shall not begin to discharge the duties of their offices until they have declared their assets and liabilities as prescribed in the Constitution of the Federal Republic of Nigeria. The chairman shall hold office for a period of 5 years and may be reappointed for another term of 5 years. Other members hold office for 4 years and can be reappointed for another 4 years. Removal of members. The chairman or any member can be removed from office by the President, acting on an address supported by 2/3 majority of the Senate. The Commission shall have a secretary appointed by the President, who, under the general direction of the chairman, shall be responsible for keeping the records of the Commission and the general administration and control of the staff of the Commission. Immunities. An officer of the Commission, when investigating or prosecuting a case of corruption, shall have all the powers and immunities of a police officer under the Police Act and any other laws conferring power on the police or empowering and protecting law enforcement agents. Duties of the Commission. A. Where reasonable ground exists for suspecting that any person has conspired to commit or has attempted to commit or has committed an offense under the Act or any other law prohibiting corruption, to receive and investigate any report of the conspiracy to commit, attempt to commit, or the commission of such offense, and, in appropriate cases, the offenders. B. To examine the practices, systems, and procedures of public bodies, and where, in the opinion of the Commission, such practices, systems, or procedures aid or facilitate fraud or corruption, to direct and supervise a review of them. C. To instruct, advise, and assist any officer, agency, or parastatals on ways by which fraud or corruption may be eliminated or minimized by such officer, agency, or parastatal. D. To advise head of public bodies of changes in practices, systems, or procedures compatible with the effective discharge of the duties of the public bodies, as the Commission thinks fit to reduce the likelihood or incidence of bribery, corruption, and related offenses. E. To enlist and foster public support in combating corruption, offenses, and penalties. A. Offense of accepting gratification. Any person who corruptly asks for, receives, or obtains any property or benefit of any kind for himself or for any other person, or agrees or attempts to receive or obtain any property or benefit of any kind for himself or for any other person, is liable to imprisonment for 7 years. B. Offense of giving or accepting gratification through agent, on conviction, shall be liable to imprisonment for 7 years. C. Acceptor or giver of gratification to the guilty, notwithstanding that the purpose was not carried out or matter not in relation to principal's affair or business, on conviction, shall be liable to imprisonment for 7 years. D. Fraudulent acquisition of property. Any person found guilty shall, on conviction, be liable to imprisonment for 7 years. E. Fraudulent receipt of property. Any person who receives anything which has been obtained by means of act constituting a felony or misdemeanor outside or inside Nigeria, which if it had been done in Nigeria would have constituted a felony or misdemeanor, and which is an offense under the laws in force in the place where it was done, knowing the same to have been so obtained, is guilty of a felony, and the offender shall, on conviction, be liable to imprisonment for 7 years. F. Penalty for offences committed through postal system. If the offence by means of which the thing was obtained is a felony, the offender shall, on conviction, be liable to imprisonment for 3 years, except the thing so obtained was postal matter, or a charter, money or valuable security contained therein, in which case the offender shall, on conviction, be liable to imprisonment for 7 years. G. Deliberate frustration of investigation being conducted by the Commission. Any person who, with intent to defraud or conceal a crime or frustrate the Commission in its investigation of any suspected crime of corruption under the Act or any other law, destroys, alters, etc. Any document shall, on conviction, be liable to 7 years imprisonment. H. Making false statements or returns. Any person who knowingly furnishes any false statement or return in respect of any money or property received by him or entrusted to his care, or of any balance of money or property in his possession or under his control, is guilty of an offence and shall on conviction be liable to 7 years imprisonment. I. Gratification by and through agents. Any person who corruptly accepts, obtains, gives, or agrees to give, or knowingly gives to any agent any gift or consideration as an inducement or reward for doing, forbearing, to do any act or thing, shall on conviction be liable to 5 years imprisonment. J. Bribery of public officer. Any person who offers to any public officer or being a public officer solicits, counsels, or accepts any gratification as an inducement or a reward in the course of official duties, shall on conviction be liable to 5 years imprisonment with hard labor. K. Using office or position for gratification. Any public officer who uses his office or position to gratify or confer any corrupt or unfair advantage upon himself or any other relation or associate shall be guilty of any offense and shall on conviction be liable to imprisonment for 5 years without option of fine. L. Any public officer who in the course of official duties inflates the price of any good or service above prevailing market price or professional standards shall be guilty of an offense under this Act and liable on conviction for a term of 7 years and a fine of 1 million naira. Code of Conduct for Public Officers. The 5th Schedule, Part 1 of the 1999 Constitution states that a public officer shall not put himself in a position where his personal interest conflicts with its duties and responsibilities. Restrictions on specified officers. A public officer shall not receive or be paid the emolument of any public office, just as he receives or is paid the emoluments of any other public office, except where he is not on full-time basis or does not engage in the running of any private business. However, no public officer shall be prevented from engaging in farming. Prohibition of foreign account. The President, Vice President, Governors, Deputy Governors, Ministers of the Government of the Federation, State Commissioners, Members of the National Assembly and of House of Assembly of the States, and such other public officers or persons as the National Assembly may by law prescribe, shall not maintain or operate a bank account in any country outside Nigeria. Retired public officers or certain retired public officers. No public officer shall, after retirement from public service and while taking pension from public funds, accept more than one remunerative position as chairman, director, or staff of a company controlled by the government or any public authority. A retired public servant shall not receive any other remuneration from public funds additionally to his pension, and the emolument of such one remunerative position. The holders of the offices of President, Vice President, Chief Justice of Nigeria, Governor, and Deputy Governor of a state are prohibited from service or employment in foreign companies or foreign enterprises. Gifts or benefits in kind. A public officer shall not ask for or accept any gift or benefit for himself or any other person in the discharge of his duties. However, he may accept personal gifts or benefits from relatives or friends as recognized by custom only. Bribery of public officers. A public officer should not receive any property, gift, or benefit of any kind as a bribe for granting a favor in the performance of his duties. Abuse of power. A public officer shall not do or cause to be done in abuse of his position any arbitrary thing which prejudices the rights of others. Membership of societies. A public officer shall not belong to a society, the membership of which runs incompatible with the dignity of his office. Paragraph 11 of the 5th Schedule, Part 1 states that every public officer shall within 3 months after the coming into force of this code of conduct, or immediately after taking office and thereafter, A. at the end of every 4 years, and B. at the end of his term of office, 1. submit to the Code of Conduct Bureau a written declaration of all his properties, assets and liabilities, and those of his unmarried children under the age of 18 years. 2. Any statement in such declaration that is found to be false by any authority or person authorized in that behalf to verify it shall be deemed to be a breach of this code. 3. Any property or assets acquired by a public officer after any declaration required under this Constitution and which is not fairly attributable to income gift, or loan approved by this code shall be deemed to have acquired in breach of this code unless the contrary is proved. Code of Conduct Bureau. Part 1 of the 3rd Schedule of the 1999 Constitution established the Code of Conduct Bureau. Composition. Code of Conduct Bureau shall consist A. A chairman and B. 9 other members, each of whom at the time of appointment shall not be less than 50 years of age and vacate his office on attaining the age of 70 years. The Bureau shall establish such offices in each state of the Federation as it may require for the discharge of its functions under the Constitution. Powers of the Code of Conduct Bureau. The Code of Conduct Bureau was set up to A. Receive declarations by the public officers made under paragraph 12 of Part 1 of the 5th Schedule of the 1999 Constitution. B. Examine the declarations in accordance with the requirements of the Code of Conduct or any law. C. Retain custody of such declarations and make them available for inspection by any citizen of Nigeria on such terms and conditions as the National Assembly may prescribe. D. Ensure compliance with and where appropriate enforce the provisions of the Code of Conduct or any law relating thereto. E. Receive complaints and non-compliance with or breach of the provisions of the Code of Conduct or any law in relation thereto. Investigate the complaint and, where appropriate, refer such matter to the Code of Conduct Tribunal. F. Carry out any other function as it may be conferred upon it by the National Assembly. Code of Conduct Tribunal. It is made up of a chairman and 2 other persons. Punishments imposed by the tribunal. The following are the punishments which the Code of Conduct Tribunal shall impose if it finds a public officer guilty of contravention of any of the provisions of the Code of Conduct for public officers. A. Vacation of office or seat in any legislative house. B. Disqualification from membership of a legislative house and from holding any public office for a period not exceeding 10 years. C. Seizure and forfeiture of the state any property acquired in abuse of corruption of office. D. Penalties that may be imposed by any law where the conduct is also a criminal offense. E. Prosecution of the public officer punished in a court of law. Nigerian Extractive Industries Transparency Initiative (NEITI) Act 2007. Objectives of the NEITI. A. To ensure due process and transparency in the payments made by all extractive industry companies to the federal government and statutory recipients. B. To monitor and ensure accountability in the revenue received of the federal government from extractive industry companies. C. To eliminate all forms of corrupt practices in the determination, payments, receipts, and posting of revenue accruing to the federal government from extractive industry companies. D. To ensure transparency and accountability by government in the application of resources from payments received from extractive industry companies. And E. To ensure conformity with the principle of extractive industries transparency initiative. Functions of NEITI. A. Develop a framework for transparency and accountability in the reporting and disclosure by all extractive industry companies of revenue due to or paid to the federal government. B. Evaluate without prejudice to any relevant contractual obligations and sovereign obligations the practices of all extractive industry companies and government respectively regarding acquisition of acreages, budgeting, contracting, materials procurement, and production cost profile in order to ensure due process, transparency, and accountability. C. Ensure transparency and accountability in the management of investments of the federal government in all extractive industry companies. D. Obtain as may be deemed necessary from any extractive industry company an accurate record of the cost of production and volume of sale of oil, gas, or other minerals extracted by the company at my period, provided that such information shall not be used in any manner prejudicial to the contractual obligation or proprietary interest of the extractive industry company. E. Request from any company in the extractive industry or from any relevant organ of the federal, state, or local government an accurate account of money paid by and received from the company at any period as revenue accruing to the federal government from such company for that period, provided that such information shall not be used in a manner prejudicial to contractual obligations or proprietary interest of the extractive industry company or sovereign obligations of government. F. Monitor and ensure that all payments due to the federal government from all extractive industry companies, including taxes, royalties, dividends, bonuses, penalties, levies, and such like are duly made. G. Identify lapses and undertake measures that shall enhance the capacity of any relevant organ of the federal, state, or local government having statutory responsibility to monitor revenue payments by all extractive industry companies to the federal government. H. Disseminate by way of publication of reports, or otherwise any information concerning the revenues received by the federal government from all extractive industry companies as it may consider necessary. I. Promote or undertake any other activity related to its functions and which in its opinion is calculated to help achieve its overall objectives as enumerated in Section 2 of this Act. J. Ensure that all fiscal allocations and statutory disbursements due from the federal government to statutory recipients are duly made. Appointment of external auditors for the extractive industry companies. According to Section 4 of NEITI Act 2007, NEITI shall, in each financial year, appoint independent auditors to audit the total revenue which accrued to the federal government for that year from extractive industry companies in order to determine the accuracy of payments and receipts. The independent auditors appointed under subsection 1 of this section shall undertake a physical process and financial audit on such terms and conditions as may be approved by the National Stakeholders Working Group (NSWG). Upon the completion of an audit, the independent auditors shall submit the report together with comments on the extractive industries companies to NEITI, which shall cause same to be disseminated to the National Assembly and the Auditor General for the Federation, and also ensure their publication. NEITI shall submit a biannual report of its activities to the President and National Assembly. The Auditor General for the Federation shall not later than 3 months after the submission of the audit report to the National Assembly publish any comment made or action taken by the government on the audit report. National Stakeholders Working Group (NSWG). The governing body of the NEITI shall be the National Stakeholders Working Group, in this act referred to as the NSWG. Functions of NSWG: A. Be responsible for the formulation of policies, programs and strategies for the effective implementation of the objectives and discharge of the functions of the NEITI. B. Having powers to recommend the annual budget and work plan of the NEITI and ensure the periodic review of programs performed by NEITI. Composition of National Stakeholder Working Group (NSWG). The NSWG shall be constituted by the President and shall consist of a chairman and no more than 14 other members, one of whom shall be an executive secretary. In making appointment into the NSWG, the President shall include 1. Representative of extractive industry companies, 2. Representative of civil society, 3. Representative of labor unions in the extractive industries, 4. Experts in the extractive industry, and 5. One member from each of the 6 geopolitical zones. Tenure, allowances, and meetings of National Stakeholders Working Group (NSWG). A. The chairman and other members of NSWG, other than the executive secretary, shall serve on part-time basis. B. The appointment of executive secretary shall be for 5 years and no more. C. A person appointed as a member of the NSWG shall hold office for 4 years and no more. D. The members of the NSWG, as well as any person appointed to any of its special committees, may be paid such allowances out of the funds of the NEITI, as the National Revenue Mobilization and Fiscal Commission may approve. E. The NSWG shall ordinarily meet quarterly for the dispatch of business at such times and places as it may determine, but not less than 4 times in a year. At every meeting of the NSWG, the chairman shall preside, and in his absence, a member of the NSWG appointed by the members from among themselves shall preside. Questions proposed at a meeting of NSWG shall be determined by a simple majority of members present and voting, and in the event of an equality of votes, the person presiding shall have a casting vote. The NSWG may at any time co-opt any person to act as an advisor at any of its meetings, but no person so co-opted shall be entitled to vote at any meeting. The validity of the proceedings of the NSWG shall not be affected by the absence of any member, vacancy among its membership, or by any defect in the appointment of any of the members. The quorum of the NSWG at any meeting shall be 8 members. Penalties for offences committed by extractive industry companies. A. An extractive industry company which gives false information or report to the federal government or its agency regarding its volume or production, sales and income, or renders false statement of account, or fails to render a statement of account required under this Act to the federal government or its agencies, resulting in the underpayment or non-payment of revenue accruable to the federal government or statutory recipients, commits an offence and is liable on conviction to a fine no less than 30 million naira. B. Where the extractive industry has been convicted of an offence under A above, the court shall, in addition to the penalties described thereunder, order the company to pay the actual amount of revenue due to the federal government. C. An extractive industry company which delays or refuses to give information or report under this Act, or willfully or negligently fails to perform its obligations under this Act, commits an offence and is liable on conviction to a fine no less than 30 million naira. D. President may, on the recommendation of the NSWG, suspend or revoke the operational license of any extractive industry company which fails to perform its obligations under this Act. E. If any extractive industry company commits an offence against the Act, every director or other persons concerned in the management of the company commits the offence and is liable on conviction no less than 2 years imprisonment or a fine no less than 5 million naira, unless that person proves that 1. The offence was committed without his consent or convenience, and 2. The person exercised all such negligence to prevent the commission of the offence as ought to have been exercised by that person, having regard to the nature of his functions in that company and to all the circumstances. F. A government official who renders false statement of account or fails to render a statement of account required under this Act to the federal government or its agencies, resulting in the underpayment or non-payment of revenue accruable to the federal governor or statutory recipient, commits an offence and is liable on conviction to not less than 2 years imprisonment or a fine not less than 5 million naira, unless that person proves that 1. The offence was committed without his consent or connivance, and 2. The person exercised all such diligence to prevent the commission of the offence as ought to have been exercised by that person, having regard to the nature of his functions in that company and to all the circumstances. General rule. A. Any officer found guilty of contravention of any of the provisions of the Code of Conduct shall appeal to the Court of Appeal. B. Prerogative of mercy shall not apply to any punishment imposed by the tribunal. Chapter review. The Nigerian government is striving to eradicate or at least reduce drastically corruption, cases of fraud, and greed within the society. The government has therefore set in place agencies to propagate the virtues of morality and in the long run punish offenders as deterrent to others in the society. Worked examples. Questions 1a. The Fiscal Responsibility Commission was established by the Fiscal Responsibility Act 2007. Outline the following. 1. Composition of the Commission. 2. Qualification and appointment of members to the Commission. B. State each sees of the functions and powers of the Commission. 2. The Public Procurement Act 2007 established the National Council on Public Procurement. Required. 1. State the composition of the council. 2. List 6 functions of the council. B. 1. What are the objectives of the Bureau of Public Procurement? 2. List 8 each of the powers and functions of the public procurement. 3a. Part 1 of the 3rd schedule of 1999 Constitution established the Code of Conduct Bureau. 1. State the composition of the Code of Conduct Bureau. 2. State 6 powers of the Code of Conduct Bureau. B. Outline the punishment which can be imposed by the Code of Conduct Tribunal where a public officer is found guilty of contravention of any of the provisions of the Code of Conduct. 4a. The EFCC was established by Act No. 5 of 2002 to combat economic and financial crimes in Nigeria. Required. 1. Outline the composition of the Commission. 2. Enumerate 8 functions of the Commission. 3. In line with paragraph 6 of the Act, state 3 powers of the Commission. B. 1. The ICPC was established by the Corrupt Practices and Other Related Offences Act 2000. State the composition of the Commission. 2. State 8 functions of the Commission. 3. Compare and contrast the EFCC and ICPC. Suggested solutions. 1a. Composition of the Commission. A chairman who shall be the chief executive and accounting officer of the Commission, 1 member from and representing the organized private sector, civil society, engaged in cases relating to probity, transparency, and good governance, the organized labor, Federal Ministry of Finance, of a level not below the rank of a director. Each geopolitical zones of the country, namely North Central, Northeast, Northwest, Southeast, South-South, and Southwest. 2. Qualification and appointment of members to the Commission. 1. All members of the Commission shall be persons of unquestionable integrity. 2. All members must possess qualifications of not less than 10 years cognate post-qualification experience. 3. The chairman and other members of the Commission, other than the ex-officio members, shall be appointed by the President, subject to confirmation by the Senate. 4. The chairman and members of the Commission representing the 6 geopolitical zones shall be full-time members. B. 1. Functions of Fiscal Responsibility Commission: to compel any person or government institution to disclose information relating to public revenues and expenditure, to cause an investigation into whether a person has violated any provisions of the Act, to forward the reports of any investigation against any person to the Attorney General of the Federation for possible prosecution, to monitor and enforce the provisions of this Act, to undertake fiscal and financial studies, analysis, and disseminate the results to the general public. To disseminate standard practices that will result in the effective allocation and management of public expenditure revenue. 2. Powers of the Commission. 1. Power to provide general policy guidelines for the implementation of the functions of the Commission. 2. Power to supervise the implementation of the policies of the Commission. 3. Power to appoint employee required for of the Commission. 4. Power to determine and approve the terms and conditions of service, including disciplinary measures for the employees of the Commission. 5. Power to fix the remuneration, allowances, and benefits of the employees of the Commission. 6. Power to regulate its proceedings in respect if meetings, notices, and keeping of minutes as may be determined by the Commission. 7. Power to perform any other functions as may be deemed to ensure efficient performance of the Commission. 2A. 1. Composition of the National Council on Public Procurement. The Council shall consist of 1. The Minister of Finance as Chairman. 2. The Attorney General and Minister of Justice of the Federation. 3. The Secretary to the Government of the Federation. 4. The Head of Service of the Federation. 5. The Economic Advisor to the President. 6. 6 part-time members to represent National Institute of Purchase and Supply Management, Nigeria Bar Association, Nigeria Association of Chambers of Commerce, Industry, Mines and Agriculture, Nigerian Society of Engineers, Civil Society, the media. The Director General of the Bureau shall be the Secretary of the Council. 2. Functions of the National Council on Public Procurement. 1. To consider, approve, and amend the monetary issues related to the Act. 2. To consider and approve policies on public procurement. 3. To approve the appointment of the Director of the Bureau. 4. To receive, review, consider, and approve the audited accounts of the Bureau of Public Procurement. 5. To approve changes in the procurement process to adapt to improvements in modern technology. 6. To perform such other functions as may be deemed necessary to achieve the objectives of the Act. 2b. 1. Objectives of the Bureau of Public Procurement. 1. The harmonization of existing government policies and practices on public procurement. 2. The establishment of pricing standards and benchmarks. 3. Ensuring the application of fair, competitive, transparent, and standard practices for the procurement and disposal of public assets and services. 4. The attainment of transparency, competitiveness, and professionalism in the public sector procurement system. B. 2. Functions of the Bureau of Public Procurement. 1. To formulate the general policies and guidelines relating to public sector procurement. 2. To supervise the implementation of established procurement policies. 3. To monitor the prices of tendered items and keep a national database of standard process. 4. To publish the details of major contracts in the procurement journal. 5. To publish papers and electronic editions of the procurement journal. 6. To maintain a national database of the particulars and classification and categorization of federal contractors and service providers. 7. To collect and maintain in a database for all federal procurement plans and information. 8. To undertake procurement research and survey. 9. To organize training and development programs for procurement professionals. 10. To prepare and update standard bidding and contract documents. 11. To prevent fraudulent and unfair procurement and, where necessary, apply administrative sanctions. 13. To review the procurement and award of contract procedures of every entity to which the Act applies. Powers of the Bureau for Public Procurement. The Bureau shall have the power to 1. Review and/or inspect any procurement transaction to ensure compliance with the provisions of the Act. 2. To review and determine whether any procuring entity has violated any provision of this Act. 3. To stop and blacklist any supplier, contractor, or service provider that contravene any provision of the Act. 4. To maintain a national database of federal contractors and service providers. 5. To maintain a list of firms and persons that have been debarred from participating in public procurement activity and publish them in the procurement journals. 6. To investigate any aspect of any procurement proceeding where a breach, default, mismanagement, and/or collusion has been alleged, reported, or proved against a procuring entity or service provider. 7. To recommend to the Council where there are persistent breaches of this Act or regulations for suspension, replacement, discipline, and temporary transfer of any officer of any procuring entity or of the Council. 8. To act upon complaints in accordance with the procedures set out in this Act. 9. To nullify the whole or any part of any procurement proceeding or award which in contravention of this Act. 10. To enter into contract or partnership with any company, firm, or person which in its opinion will facilitate the discharge of this function. Composition of the Code of Conduct Bureau. Code of Conduct Bureau shall consist of the following: 1. A chairman. 2. 9 under members, each of whom at the time of appointment shall not be less than 50 years of age and vacate his office on attaining the age of 70 years. The Bureau shall establish such offices in each state of the Federation as it may require for the discharge of its functions under the Constitution.